Hello, everybody, and welcome to History/Law Bite number 211, dated March the 15th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Supremecourtology 101. You might not be aware of it, but I am a huge U.S. Supreme Court buff. You know, the Supreme Court of the United States is my favorite branch of the U.S. federal government. It has been ever since I was in high school, some 2 decades ago. And it was once a career aspiration of mine to be appointed an Associate Justice of the U.S. Supreme Court. Meeting Justice Clarence Thomas in person in his chambers at the court in 2004, only strengthened my resolve to achieve that goal. But as the old saying goes, if you want to make God laugh, tell him your plans. As such, as we get older, aspirations do often change, as was the case with me here. But what has not changed is my love for the court as an institution. And I'm pretty sure that I am not the only Supreme Court buff out there. All right? So, with this video, I have compiled a litany of different arbitrary facts and pertinent history about the Supreme Court of the United States. It's all of this information is research that I've performed on my own and compiled into a giant list. And I'm reading to you from the list. I'm not reading from an internet page. This is all heavy research that I've done and compiled and, giving it to you here to enhance your knowledge on the Supreme Court as an institution. All right. Some of these you may already know. Some of them may make you say, really? In any case, that's the point, to expand the mind and to learn. So let's get started. All right. The Supreme Court, first of all, did not have its own building until 1935. How many of you knew that? In the early days of the Republic, when New York was the national capital from 1789 to 91, the Supreme Court met in the Merchants Exchange Building. All right? During the period when Philadelphia was the national capital, from 1791 to the year 1800, the court met briefly in Independence Hall. All right, and in Old City Hall while in Philadelphia. When D.C. became the national capital in 1800, the court would sit in various locations within the U.S. Capitol building until the current magnificent structure that it sits in today was completed in 1935. It was then that the Supreme Court finally had a place to truly call home. Next, the Supreme Court, like all other federal courts, has its own bar, or roster of attorneys permitted to practice law before them. You cannot argue in front of the Supreme Court if you are not a member of the Supreme Court bar. No exceptions. Every lawyer initiating their argument at the Supreme Court begins with this very specific phrase: Mr. Chief Justice, and may it please the court. Don't forget that either. In November of 1980, in anticipation of the first woman being appointed to the Supreme Court, the justices abandoned the use of Mr. preceding their title of justice in the opinions of the court and in other formats, and simply began using justice as opposed to Mr. Justice. The one exception, is the Chief Justice, who, when being spoken to, is referred to as Mr. Chief Justice. The first official record of the Supreme Court of the United States, dated on February the 2nd, 1790, contains a misprint in the very first line, and most people wouldn't even notice it. It reads, "In the Supreme Judicial Court of the United States." Where's the mistake at? You don't know? How about the word judicial? It is a mistake because the clerk, who was a Massachusetts man, made the error, likely dreaming about the highest court in his own state of Massachusetts, which is known as the Supreme Judicial Court. The Supreme Court of the United States does not use the word judicial in its title. Next, 115 justices have served on the U.S. Supreme Court since 1789, when the court came into existence. 17 of those individuals have been Chief Justices. The first Chief Justice was John Jay, who was appointed by President George Washington in 1789. Jay served from that time until he resigned in 1795 to become Governor of New York, a much more prestigious office at that time. 3 incumbent Associate Justices have been elevated to Chief Justice. Talk about a promotion, huh? These men were Edward White in 1910, Harlan Fiske Stone in 1941, and William Rehnquist in 1986. One former Associate Justice who resigned was reappointed as Chief, Charles Evans Hughes, in 1930 by President Hoover. Another associate also received such an appointment after previously serving and then resigned. That would be John Rutledge in 1795. We'll get to more about Justice Rutledge in a moment. The longest serving Chief Justice was John Marshall, the 4th Chief Justice, who served from February 1801 till July of 1835. 34 years, 5 months, and 2 days, the longest serving chief in history. The shortest serving Chief Justice was John Rutledge. Told you we'd get back to him real quickly. Now, Rutledge served 138 days as Chief Justice from August to December of 1795. Rutledge was previously an Associate Justice who resigned after 383 days of service in 1791. He was given a recess appointment by President Washington as the Chief Justice, all right? So, Rutledge holds a few records here. First, he was the first justice to be given a recess appointment to begin with, all right? When he was reappointed by Washington, this time as Chief Justice, all right? And in his recess appointment, he would be rejected by the Senate to be Chief Justice. So, Rutledge was the first recess appointment justice. He was the first recess appointment justice and the only one to date to not be confirmed by the Senate. And he became the very first Supreme Court nominee ever to be rejected by the Senate, period, regardless of recess or regular appointment. Did you know that? All right, this is John Rutledge, all right, 1795. The longest serving Associate Justices were William O. Douglas and Stephen Field. Douglas served on the court for 36 years, 7 months, and 8 days from April 1939 to November 1975. Field served on the court for 34 years and 6 months from May of 1863 to December of 1897. Douglas also holds many more Supreme Court records. He wrote more books, more than 30, racked up more marriages, 4 of them, more divorces, 3 of them, and more impeachment attempts, 2 of them, than any other justice in the court's history. William O. Douglas was a character indeed. Great guy. Not sure where his head was all the time, but excellent justice. In May of 1881, Justice Stanley Matthews was confirmed by a Senate vote of 24 to 23. No other justice in history has been confirmed by a single vote. None to date. The oldest justice to be appointed to the court was Justice Horace Lurton in 1914. He was age 65 upon taking office. The oldest justice to retire from the court was Oliver Wendell Holmes in January of 1932, who at the time of his retirement was 90 years of age and 10 months. He was 2 months from turning 91 years old. The youngest person ever appointed to the court was Justice Joseph Story, who was age 32 upon taking office in 1811. He was a James Madison appointment. A legend as well, I'll add. The number of Supreme Court justices, folks, is determined exclusively by Congress, not the Constitution, as many mistakenly believe. If Congress wanted to create a court of 20 people, there is nothing stopping them from doing that. If they wanted to create a court of 2 people, there is nothing stopping them from doing that. But it must be at least 1, because the Constitution does create a Supreme Court. Therefore, the Congress has to create something in the name of a Supreme Court, and therefore at least 1 person has to be a Supreme Court. So, the court currently, as we already know, has 9 justices, a number which it has had since 1869, all right, when that number was set by way of the Judiciary Act of the same year, 1869. The first Supreme Court had only 6 justices, for the record, 1 chief, 5 associates, okay? From 1789 until 1891, in addition to their Supreme Court duties, U.S. Supreme Court justices also rode circuit and sat as trial judges on individual judicial circuits throughout the Republic. So during that time period, from 1789 to, 1891, 9 chances out of 10, the vast majority of appeals the Supreme Court was hearing were cases that had been already adjudicated by one of the justices sitting on the court. All right, they had already ruled on the case as a trial judge. So it was, I think the whole circuit riding thing was ridiculous, but the motive behind it was to keep the justices close to the people. Okay. President Franklin Roosevelt appointed more justices than any other chief executive. 8 associate justices in total between 1937 and 1943, and 1 chief justice, Stone, in 1941, who was elevated from the ranks. All right, Stone had been an associate justice appointed by President Coolidge in 1925 and was elevated to chief by Roosevelt in 1941 in a spirit of bipartisan unity, as Stone was a Republican. James Burns, who was appointed in 1941, was the last justice named to the court who had no law degree. And Stanley Reed, who retired in 1957, was the last one to serve on the court with no official law degree. All right, he attended law school but did not finish. The first justice appointed who had attended law school, per se, was Levy Woodbury, all right, who served from 1845 to 1851. William Howard Taft is the only former president to serve on the Supreme Court as its Chief Justice, as we all know, from 1921 to 1930. Louis Brandeis was the court's first Jewish justice, appointed by President Wilson in 1916 and serving until his retirement in 1939. Benjamin Cardozo was the court's first justice with any Latin heritage. He was appointed in 1932 by President Hoover and served until his death in 1938. Thurgood Marshall was the Supreme Court's first African-American and non-white Supreme Court justice. He was appointed by President Lyndon Johnson in 1967 and served until his retirement in 1991. His successor, Clarence Thomas, is only the second African-American to serve on the U.S. Supreme Court since its inception in 1789. In 1986, Antonin Scalia became the court's first Italian-American justice, and in 2006, current Justice Samuel Alito became only the second Italian-American justice to serve on the Supreme Court. With Justice Stevens' retirement in 2010, until the appointment of Neil Gorsuch in 2017, for the first time in the court's history, it had no members who identified themselves as Protestant Christians. Instead, all of its members identified either as Catholic Christians or Jewish. As of 2021, the court has 6 Catholic justices, 2 Jewish justices, and 1 Protestant justice. In 1836, Roger B. Taney of Maryland, appointed by President Andrew Jackson, became the court's first Catholic justice, and the Chief Justice at that. He served until his death in 1864 at the age of 87. All right? It would take another 58 years for the next Catholic justice to arrive on the court, Edward White of Louisiana, in 1894. In history, 5 women in total have been appointed to the Supreme Court of the United States. Sandra Day O'Connor was the court's first female justice, appointed by President Ronald Reagan in 1981 and serving until 2006. She is also the most recent justice to have any legislative branch experience, having served as a member of the Arizona State Legislature and as a state judge before arriving at the Supreme Court in 1981. While attending law school at Stanford, she dated future Associate Justice and future Chief Justice William Rehnquist. Did you know that? After Rehnquist graduated, he proposed to her, but she respectfully declined. O'Connor received 4 proposals while a student at Stanford Law. She is also the last living justice who was a member of the Burger Court, headed by former Chief Justice Warren E. Burger. All right? And, of course, you know that O'Connor and Rehnquist served together on the Supreme Court from 1981 until his death in 2005. Sonia Sotomayor was the court's first Latina justice, appointed by President Obama in 2009, and she is still presently serving on the court, of course. The court's other female justices have been Ruth Bader Ginsburg, who served from 1993 to 2020, Elena Kagan, appointed by President Obama in 2010, and of course is presently serving, and Amy Barrett, who was appointed by President Trump in 2020 and is also presently serving. Justice Ruth Bader Ginsburg is the most recent justice to die while still in office on the court. She passed away, of course, on September 18th, 2020 at the age of 87. Justice Elena Kagan is the most recent appointment to the court who had no prior judicial experience whatsoever. Former Justice David Souter is the most recent member of the court who had experience as a state judge, both at the trial and appellate level in the state of New Hampshire, his home sweet home. Most recently, in January 6, 2016, the Supreme Court had 4 New Yorkers serving as justices: Scalia, Ginsburg, Sotomayor, and Kagan. Each represented a different borough of New York City. Scalia, the borough of Queens; Ginsburg, Brooklyn; Sotomayor, the Bronx; and Kagan, Manhattan. Did you know that? So we had a New York Supreme Court. Justice Anthony Kennedy is the most recent retiree from the U.S. Supreme Court, all right? Stepping down in 2018 after 30 years of service at the age of 82 and being succeeded by Justice Brett Kavanaugh, all right? Kennedy was the last justice to leave the court, who served alongside Justice Thurgood Marshall. The two served together from 1988 to 1991. There has been only one period in the court's history when a white and a black served together. Specifically, what I'm referring to is Justices Hugo Black and Byron White. These 2 distinguished gentlemen served on the court together between March of 1962 and September 1971, when Black retired. Okay? There have been 2 Justice John Marshall Harlans, all right, who happen to be grandfather and grandson. John Marshall Harlan, granddad, served between 1877 and 1911. And John Marshall Harlan II served between 1955 and 1971. The grandson was a much more conservative jurist than his grandfather. Justices Stephen Field and David Brewer were respectively uncle and nephew, all right, and served together on the court between December of 1889 and December of 1897 when Uncle Stephen retired. More than 8,000 cases are appealed to the U.S. Supreme Court annually from lower federal courts and from state Supreme Courts, but only about 65 to 85, if you're lucky, are accepted for review. Retirement from the court is governed by the Rule of 80. All right. Once a federal judge reaches the age of 65 and they've served at least 15 years, they may retire on full salary. The same is true if they're 70 years of age and have served for 10 years, and so forth and so on. Any combination of age and service that equal the number 80 make them eligible for retirement at full salary. Not a bad deal, all right? In 1789, the first year of the court's existence, salaries were as follows. The Chief Justice was paid $4,000 annually, and the associates $3,500 annually. Of course, when adjusted to 2021 figures, that's a whole lot more than that, of course. As of January 2021, salaries are as follows. The Chief Justice, John Roberts, is paid $280,500 per year. The Associate Justices, $268,300 per year. If you're wondering why the Chief makes a little bit more, that is because he has administrative duties responsible for running not only the Supreme Court, but for administering the entire federal judiciary. So, yes, he deserves that little bit of extra dough. Before 1869, there were no federal judicial retirement plans, and most Supreme Court justices worked literally until the day they died or resigned to take other positions. Supreme Court justices, like all Article III federal judges, are granted life tenure, okay, and are only removable by way of impeachment and conviction, all right? They also leave their seats by way of death, retirement, and resignation. Most voluntarily leave by way of retirement. After retirement, Supreme Court justices are eligible to be recalled, if they wish, by the Chief Justice to serve on lower federal courts as needed, but not on the Supreme Court itself in the event of vacancies. They are also entitled to maintain chambers in the Supreme Court building and employ law clerks. Currently, there are three living retired former justices. Sandra Day O'Connor from 2006, Justice David Souter, who retired in 2009, and Anthony Kennedy, who retired in 2018. In 2005, William Rehnquist became the first Chief Justice to die in office since Frederick Vinson in 1953, some 52 years earlier. Vinson was, to date, the last Chief Justice appointed by a Democratic president, Harry S. Truman, in 1946. In 2016, Justice Antonin Scalia became the first Associate Justice to die in office since Robert Jackson in 1954, some 62 years earlier. Only one Supreme Court justice has ever been impeached, Justice Samuel Chase in 1804. He was acquitted a year later in 1805, and due to the extremely partisan nature of his impeachment and subsequent acquittal, no other member of the High Court has ever been impeached since that time. But Justice Abe Fortas came dangerously close to impeachment in 1969 due to alleged financial improprieties while serving as a justice. He resigned from the court in May of 1969 to avoid a very likely impeachment. Several former law clerks have gone on to become justices themselves. Okay, Byron White clerked for Justice Frederick Vinson during the 1946 term. William Rehnquist clerked for Justice Robert Jackson during the 1952 term. Anthony Kennedy clerked for, forgive me. Elena Kagan clerked for Justice Thurgood Marshall during the 1987 term. Neil Gorsuch clerked for Justices Byron White and Justice Anthony Kennedy during the 1993 term. All right. And Brett Kavanaugh clerked for Anthony Kennedy during the 1993 term. All right. Kavanaugh is the only justice in history to replace the justice for whom he once clerked. Okay. John Paul Stevens clerked for Justice Wiley Rutledge during the 1947 term. Stephen Breyer clerked for Justice Arthur Goldberg during the 1964 term. Chief Justice Roberts clerked for Justice William Rehnquist during the 1980 term. All right. So all of these people obviously are very familiar with the court as an institution. All right. Amy Barrett, our newest justice, clerked for Justice Antonin Scalia during the 1998 term. The first female law clerk at the court was Lucille Lohman, who clerked for Justice William O. Douglas during the 1944-45 term. Okay? Another female clerk would not be hired for the next 2 decades. Her name was Margaret Cochran, and she would not be hired until 1966. During his time on the court, from 1970 to 1994, Justice Harry Blackmun would hire more women as law clerks than any of the colleagues with whom he served. The first African-American law clerk was William T. Coleman, who clerked for Justice Felix Frankfurter during the 1948-49 term. Okay? Another notable African-American law clerk was Tyrone Brown, who clerked for Chief Justice Earl Warren during the 1967-68 term. All right? Mr. Brown played a significant role in drafting Warren's landmark Terry versus Ohio opinion in 1968. Okay? Several justices were born in foreign countries. Were you aware of that? Justice James Wilson was born in Scotland. Justice James Iredell was born in England. William Patterson was born in Ireland. Justice David Brewer was born in Turkey. Justice George Sutherland was born in England. And Justice Felix Frankfurter was born in Vienna, Austria. All right? President Jimmy Carter was the only full-term president in the 20th century who made absolutely no Supreme Court appointments. Even Gerald Ford, who immediately preceded Carter in the presidency and served roughly half of Nixon's second term out, got one appointment, Justice John Paul Stevens in 1975. Stevens is also the most recent former justice to die. He passed in July of 2019 at the age of 99. We lost a great one with Justice Stevens. Earl Warren, Chief Justice Earl Warren, is the only former state governor to be appointed to the Supreme Court and as its Chief Justice. Can't beat that with a stick. In 1965, President Lyndon Johnson persuaded Arthur Goldberg to resign his position on the court to become U.S. ambassador to the UN. He never returned to the court. That was a silly move by Arthur Goldberg. I mean, I think we can all agree with that. Justice Robert Jackson took a leave of absence from the court to be the chief prosecutor at the International War Crimes Tribunal in Nuremberg, Germany after World War II from 1945 to 46. He returned to the court once this extra service was completed. When Justice Jackson died in 1954, the remaining 8 members of the court traveled together to attend his funeral. To date, that is the last time the entire Supreme Court would travel together for obvious security reasons. Justice James McReynolds, who was appointed by President Wilson in 1914, had a reputation for being a cantankerous, evil, and exceptionally racist and anti-Semitic man. And unlike others, he was forward and open with his. McReynolds would turn his back on African-American attorneys arguing before the court. Literally. All right? And he refused to speak to Justice Louis Brandeis for much of the time they served together. 25 years. From all the way from 1916 to 23 years from 1916 to 39. Both were appointed by President Wilson, but the two appointments could not have been more different, almost like Souter and Thomas by the first President Bush. No offense to either Justices Souter or Thomas, with respect to McReynolds, of course. I'm just saying the difference in their ideologies. When McReynolds retired from the court in 1941 and died in 1946, few mourned his passing, either on or off the court. And last but not least, Justice William J. Brennan Jr. spoke of resigning from the court in the early 1970s if President Richard Nixon seriously considered putting a woman on the bench. That was the first time that any president seriously considered naming a woman to the Supreme Court under the Nixon presidency. So that about wraps it up. If you made it this far, thank you so much for listening, and I hope you gained a thing or two from this. All right. As I've said before, I'm a huge Supreme Court buff. I've got loads of books about the U.S. Supreme Court, having been a member of the Supreme Court Historical Society. This is an 1899 bound version of a U.S. Reports book containing Supreme Court decisions. All right, this book is very old, from 1899, and has several Supreme Court decisions in it. Cases from that era tended to be very business-oriented, talking a lot about railroads and other things. My goodness. Boy, how interesting, huh? Yeah, and so, but if you have any questions, controversies, or anything of the like, leave them down below and I'll be happy to answer them. Like I said, I hope you learned a thing or two from this. The Supreme Court, like I said, it's my favorite branch of government. It's a vast institution with a whole lot more to it than what I've mentioned here. If you think this was a lot of info, this is just all I felt necessary to put in the video. If you have any questions, just ask me. I can tell you more information. All right. If you've not subscribed to my channel, I humbly invite you to do so now. Just please hit that little red subscribe button right there, and we'll be in business. Your support is appreciated. And if you'd like to donate financially to my channel, links are provided on the main page. Again, thank you all so much for listening to this history/law bite. Hopefully, you gained some insight and increased your knowledge about our nation's highest court. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.